now we're going to talk about changes in the courtroom.
The next time you serve on a jury, it's going to be a little different experience for you.
Yeah, under new jury rules, you'll now be able to take notes, and if you have questions for the witnesses, you can actually submit them to be asked.
All right, joining us live in the studio to talk about this is Moshe Shein, prosecutor.
Former prosecutor.
From Broward, and then, of course, we have
Schaet.
All right, so you guys are here talking about this. One is for and one is against. First, let's talk about actually what this is and how this started. Would you like to address that?
Essentially now in criminal trials, the jurors have an opportunity to send notes to the judge and ask that certain questions be asked of the witnesses so that they can get a better understanding of how to make a proper choice.
Okay, Moshe, former prosecutor, good idea, bad idea?
I think it's a good idea. The whole point of this is truth. God forbid an innocent man should go away, be sent away to prison because some information didn't go out in the trial that the attorneys didn't bring out appropriately. We don't need any of that. So in truth, we need all this information to come in.
Stephen Schaet, good idea, bad idea?
I think it's a bad idea. I think the jury is supposed to be a neutral party. They shouldn't interject into the state attorney's job or the defense attorney's job. I think that when they start asking questions, they're no longer neutral parties. They're actually doing the job of the prosecutor. It's the burden of the state to prove that the defendant is guilty beyond every reasonable doubt, not the juror's job.
Would some people argue it's not a matter of remaining neutral, it's just a matter of being informed?
Well, some of the questions that they ask may not be what we are allowed to ask as defense attorneys or as state attorneys. So it could actually cause a mistrial if, for some reason, that a judge allows a question that shouldn't come in. It's going to open up a whole new area of appellate opinions.
But I guess, Moshe, the argument here is that the judge would know what can be answered or what can't be answered.
Yeah, these questions would be dealt with outside of the jury. So if something was asked by the jury that would be inappropriate or the rules of evidence don't permit, the jury wouldn't be there to hear it so that they wouldn't be able to take sides afterward.
Okay, so for example, if a juror says, is he in jail right now, and the judge says, we can't answer that, then the juror goes, aha, he is, then it works against you. Is that what you're talking about?
Exactly. They're going to draw an inference. If you say, has this individual ever been in prison before, and they say, we're not allowed to answer that question, the juror's going to just infer, he must have been in prison at one point in time.
Now, why is this actually, why did it start? What was the impetus to this whole thing?
Well, the Supreme Court had asked for a committee to do some referencing to find out what should be appropriate. And after 111 pages of report writing,
of course,
it was determined that this was best. It would increase the accuracy of the jury's findings. It would have the jurors paying attention more because they would be listening throughout the case and being active participants. You have to remember, sitting inside a jury area for a whole day or 5 days or 10 days can really be draining. This way the jurors will have an opportunity to be part of the process and pay attention more.
Now, this has been in effect since January 1st?
Correct.
And have you all had jurors pop up asking questions yet in either trials that you guys have been involved with?
I had a trial last week. They didn't come out and ask questions, but there's also a new rule that they're allowed to take notes. And all of the jurors on my panel feverishly were taking notes and not quite paying attention to the actions of the party that was on the stand.
Okay, so you also think the note-taking is a bad idea?
I think in the small trial, this was a one-day trial. I think that you should be able to pay attention just for that and remember everything that was said. In a 5-day, 10-day, 20-day trial, as Mr. Shein was saying, I think that it's probably important then because you're not going to remember all the details.
You agree with that?
I think that there's really no problem with them taking notes either, as long as they are reminded here or there that they have to be paying attention to the program in front of them instead of just what's down on the paper.
One of the arguments against it would be the fact that it would throw off the strategy of a lawyer. What do you think about that?
Lawyers have been trained to think on their feet. A lawyer who can't think on his feet shouldn't be in the courtroom in the first place.
What do you think?
I completely agree with that.
It's going to throw off your strategy, huh?
What about other states doing this? This was just passed in Florida. Do a lot of other states do this?
There are other states that do allow it. It's not in all 50 states. There are talks about implementing it in different states as we speak. I think it's gradually going to turn towards that way.
All right, thank you so much, Moshe Shein here and Stephen Schaet talking about the issue. Thank you guys for coming up.
Thank you very much.
Coming in so early and talking about this. Pretty good points on both sides.